Good morning. Happy 2020. This is weird, and I don't know why this happened. I went to go start making a video. This is my video on sovereign citizen arguments rebutting or responding to Blue Bacon. And I was looking for this highlighted comment, this specific one. And I didn't see it. It's not in here. It's not in here. This is the weirdest thing ever. It's not in here. So I went to my YouTube studio and I found it in here. Then when I opened it up over here with the highlighted comment, it shows 154 comments, and here it shows 150. 154. 150. Over here, I saw, here's I'm a Dork, or Christopher DeLaughter. I'm a Dork. There's Christopher DeLaughter. There's I'm a Dork. I thought I saw someone else in there. Here. Verbal Kint. 24 replies. That's so weird. Let's see what they're doing. Obviously, we're down to Captain Jack asking somebody 17 hours ago if they're homosexual, because Captain Jack is very much enamored with the idea of sodomy and being homosexual. I'm not here to judge. And it's the same one. That is just so weird. 14 replies on Teresa Richard. 13 replies on Teresa Richard. This one's down to King 9 Village Idiot. King 9 Village Idiot. Interesting. Well, let's do this, just so we know. I'm refreshing that one. Good evening. 154 comments. And I will refresh this one. Good evening. This is going to be a very short. Now this one's 154 comments. Interesting. So there must have been 4 comments from the time I loaded this up. But is that comment from Blue Bacon showing up? And it's not. This comment right here from one day ago, I hate to be the bearer of bad news, does not show up in here. So weird. Anyway, now that I've wasted way more than enough of your time, well, I guess I don't really need this one since what I'm looking for isn't there. Let's discuss some things. First of all, I'm just going to start off with the easy one. You might notice that he stopped responding on this particular thread. He says, I hate to be the bearer of bad news, but People v. Ratz was overruled and disapproved of by People v. Gutierrez in 1964. Surely a lawyer would find a real and applicable case right. It is still applicable, and I point that out. It was overruled on other grounds by People v. Hernandez, not Gutierrez. But it is overruled on other grounds, and I state the other grounds. Ratz was a statutory rape case, and People v. Hernandez was a statutory rape case. In People v. Hernandez, the lady who was raped, statutorily raped, was 17 years and 9 months old, and she was consenting, and it was a 3-month difference. The guy who had sex with her, who allegedly statutorily raped her, had reason to believe, good, valid grounds to believe that she was 18 years of age or older. But Ratz had a hardline rule that there is no defense to statutory rape. It doesn't matter that you have a reasonable good faith belief that the gal that you're having intercourse with is of age. And so what Hernandez did is it removed that portion. It specifically dealt with that portion. The charge of statutory rape is defensible wherein a criminal intent is lacking. That's what they changed there. The other big thing is that he cited a bar journal that also cited rats. But the point is that you can still cite rats. Rats is still a citable case for the proposition that a person can testify to their own age. And there are other cases out there. This is just a small sample of cases that I found in about 2 seconds from California that are still good law. People v. Ellis, People v. Gordon, People v. Velasquez, that cite two rats for the proposition that a person can testify as to their own age. And he dropped this one like a hot rock, but he still believes, and he still brings up, he subsequently, after this, brought up again that I am relying on an overruled decision that is no longer applicable, but it is still applicable. You can cite to overruled cases if they are overruled on other grounds. The rule on citing to an overruled case is that you have to state that it was overruled on other grounds, and you have to link to the other case that overruled it so that the judge reading the motion or the pleading, whatever you want to call it, can verify that it was in fact overruled on other grounds. And I didn't feel a need to do that, but I guess I should have, because he doesn't understand these things. But this is what I have been just laughing my balls off on, because Blue Bacon has figured out really quick that 804, Federal Rule of Evidence 804, which requires an unavailable declarant unavailable, see 804 requires an unavailable declarant. He has figured out that he screwed up, but he's going to try desperately to reverse engineer some salvation to his argument. I don't know why he wants to do this. I mean, doubling down on defeat is never the best option, but I guess you really want to do it. So he says, just so you all are keeping up with the discussion, because he has to continually start new threads. I don't know why. He can't maintain a single thread. I think it's because he gets his ass kicked in a thread, and then he feels like he needs to start a new one for a fresh start. But he says 804 would apply because the mother is not required to testify to her child's birth date. Now, where he got that from, I don't know. You can subpoena witnesses. You can subpoena witnesses and compel them to testify. They can be held in contempt of court if they refuse to testify. Now, if the mother does refuse to testify, then she would be an unavailable declarant, and you can use some other writing of hers to evidence the claim of the child's birth date, a birthday card that she wrote or to the child, or a letter that she wrote to someone else, a diary entry, something that the mother stated, because the mother would be the declarant. The mother has actual personal knowledge of the child's birth date. She was there. She was aware of the date. She was aware of what was going on. She knew how dates worked. She had personal knowledge of the date and the time and the location and what was going on. So she would be the declarant because she has personal knowledge. And he says this would make her unavailable as a witness. Well, if she does refuse to testify, then that would make her unavailable as a witness. Yes. But the hypothetical that we're addressing was whether the sovereign citizen stating his own birthday would be hearsay. And it is not hearsay, as I have very succinctly pointed out through case law. citing a statute leaves the statute open to interpretation. That's why you always want to start off with the cases. And if, just as a quick help for anybody out there who is ever going to write a pleading, if you do write a pleading and it does require a table of contents, you start off with case law first. The very first thing in your table of contents when it comes to citations, because you do have to put citations in your table of contents, your citations will start off with case law. Then it will go to constitutions, then statutes, then other sources. So, and the reason why they do that is because case law determines what the statutes and constitutions mean. And then you go to the actual text of the Constitution. Constitutions would overrule a statute, bless you, and then you go to the statutes themselves. So starting off at the statute is just a rookie maneuver. So anyway, again, what we were looking at was whether the sovereign citizen stating his own age would make his statement of his birthday hearsay. So he's just completely off track. Anyway, I'm going to skip most of this. The best statement ever, and I just giggled my balls off on this one. He says right here, if his birth date, I'm assuming he's talking about the sovereign citizen. If the sovereign citizen's birth date was hearsay, as he claims, since he was told his birth date and isn't mentally capable of remembering the actual event of his birth, it is still admissible in court under 804. That is the dumbest thing ever. Let me try to help you out. The person who told the sovereign citizen his birth date would be the declarant. That is the person who has to be unavailable in order for 804 to apply. And there are other issues that are required. So the first thing that we're going to do is we're going to look at 804. 804 would require a declarant is considered to be unavailable as a witness if the declarant, and then this is what we're looking at right here, testifies to not remembering the subject matter. So where you would see this typically would be, somebody writes a letter detailing some interaction 20 years ago, and that somehow becomes relevant to a current ongoing litigation. And you want that person who wrote the letter to come testify about that subject matter. And that person says, I don't fucking remember that. That was 20 years ago. I have no recollection of it. Well, the first thing you try to do is you try to show them the writing to refresh their recollection. And if they say, I don't remember writing this. You know what? I had a stroke a few years back. I just don't remember this. Then what you can do is you could put the person on the stand. They could say, look, I don't remember this. I had a stroke. I don't remember certain things about that time frame. I don't remember it. And then you could try to introduce that letter into evidence. That letter would be hearsay because it is an out-of-court statement that is offered by a party for the truth of the matter asserted therein. You could offer that letter into evidence. The declarant would be the person on the stand, but he would have presumably knowledge of what was in that letter, at least at the time he was writing it. But I kind of forecast where I was going. But first, you've got to have personal knowledge. And as to firsthand knowledge on the part of hearsay declarants, see the introductory portion of Advisory Committee's note to 803. It does require firsthand knowledge. Whoops, I went too far. 803 is going to reference back to 602, but let's go to 803 first. All right, so this is 803. This is exceptions to the rule against hearsay. And in a hearsay situation, the declarant is, of course, a witness. So the declarant would be the witness And neither this rule nor 804 dispenses with a requirement of first-hand knowledge. It may appear from his statement or be inferable from circumstances. So the witness still has to have first-hand knowledge. And first-hand knowledge is Rule 602, need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony under 703. Personal knowledge means that you have sensory knowledge about what happened. You were conscious, you were aware, you knew what was going on. You have personal knowledge of it. I saw X. I heard Y. I felt Z. Touch, taste, smell, all of those things. You need to have sensory knowledge of the actual thing you're testifying about. So if we go back to this, if his birth date was hearsay as he claims, so the sovereign citizen is claiming that his birthday is hearsay, since he was told his birth date, he wasn't there. He was there, I guess, but he doesn't have any sensory, he doesn't have firsthand personal knowledge of it. He wasn't aware of what was going on. Nobody remembers their birthday. Nobody was conscious of what a date was, let alone what the actual date was when they were born. On the day of your birth, you don't know what a date is. You don't know what a day is. You don't know what time is. All you know is you want milk, you want to poop, you want to pee, you want to cry, and you want to sleep. Not necessarily in that order. So the witness, the sovereign citizen, would lack personal knowledge. Since he isn't mentally capable of remembering the actual event of his birth, it is not admissible in court under 804 because he didn't have personal knowledge. Now, for example, if he wrote a note to himself about an event, or let's say he wrote a note to himself about his birthday. I mean, we're way off in the weeds. This is really stupid. The easiest way to prove your birthday, if you want to prove your birthday, is to testify to it, because obviously you can, it's not hearsay. Another easy way is to introduce your birth certificate in there, and you're saying, oh, well, the birth certificate is an out-of-court statement offered by a party to prove the matter asserted therein. Well, yes and no, but there are exceptions for public records. There are exceptions for the business documents, things that are made in the ordinary course of business. The hospital makes these birth certificates in the normal course of business. There's no indicia of any attempt to, be fraudulent. So there's no, it's a hearsay exception. So they could bring in as long as they authenticate the document, they could bring in a birth certificate. You could bring in the doctor who was there, who performed assisted the woman in giving birth. Anyway, so there are easy ways to do it, but let's say for whatever reason, the person was born outside of a hospital. There's no birth certificate for whatever reason. He wrote a note to himself. He marked on his calendar every year his birthday, and then he had a stroke or something like that, and he no longer remembers his birthday. So you get him up on the stand. He might say, I don't remember my birthday. I knew it at one point in time, but I don't remember it now. And I'm incapable of learning when my birthday was, but even, I'm incapable of remembering even by having my recollection refreshed by reviewing my previous writings. And so then you would be able to theoretically introduce like the calendars or whatever. But the point that Blue Bacon doesn't understand is who the declarant is, because you could have multiple levels of hearsay. If Anna wrote a diary entry that Susie told Bonnie that Yvette went to the movies on Friday night with Zach, and you want to get that diary entry in there. Let's say that I forget the names. So A has a diary entry that says B told C that D went to the movies on Friday night with E. All right. So you want to get that diary entry in there, but A is unavailable for whatever reason. Doesn't remember, comatose, out of the country, refuses to testify, whatever. And you want to introduce that diary entry because you want to prove that D went to the movies on Friday night with E. Well, you'd say, well, I have a hearsay exception because the declarant, A is the declarant, right? A wrote the diary entry, A is unavailable. Well, here's the problem. What A wrote in her diary is also going to be hearsay because B told C this. So B is the declarant now for the second level of hearsay. So then you'd either have to prove that B is also unavailable. Well, actually, technically, you'd have to prove that B has firsthand knowledge that D went to the movies with E, like heard them, saw them, whatever, saw them at the movies, etc. Or that might be a third level of hearsay. But anyway, you have to prove each level of hearsay. There has to be an exception for each level of that hearsay in order for it all to come in. Ultimately, every single level has to have an individual justification. That's how declarants work. And I know it's complicated, and I know Blue Bacon doesn't understand it, but 804 just would not apply because you'd have to prove the declarant, the person who told the sovereign citizen, assuming the sovereign citizen's theory, because Blue Bacon buys into the sovereign citizen's theory for whatever reason, that it is hearsay and therefore requires an exception. It's not hearsay. It doesn't require an exception. It's just not. And if a court ever does determine that it is, you would go to 803, because in 803 you could say, well, my parents have always told me, my family has always held that my birth date was on January 1st of 2020. So, that's my birthday. And that would be acceptable as far as actual getting around the hearsay. It'd be 803. Again, 804 wouldn't be the sovereign citizen on the stand. So he's just wrong and he doesn't understand what the declarant is. Anyway, that's it. I might make a video. I'm thinking about making a video on Eric Brandt today, and I think I'm going to try to make another video on Winehouse because I have some extra material that I have found. So if you don't get notifications for those, well, they might be coming or they might not. But thanks for watching. Have a great day.